Happy to be here today. I have to tell you, I am not the greatest of planners because as I was going out the door this morning, I mentioned to my wife that we were going to be coming up here for this today, and she said, "We're going to Tahoe tomorrow. Why aren't we staying in Sacramento tonight?" I don't know, so I'm driving back home to San Jose after we get done here, then coming right back up tomorrow. But I am glad to be here, and let's see, I think Christine's got us set up. Oh, just a second. So anyways, if you've been with us before, I've actually kind of carried over the same outline that Ray Coates, who had been our coverage guru and who retired in 2010, I've kind of adopted his same outline. So what we try to break it into is most recent decisions of the Supreme Court and then pending cases. And the most recent decisions we have from the Supreme Court, we have one from 2014 and one from 2015, both involving Hartford Casualty. The Hartford Casualty versus Swift distribution case, it's kind of an interesting one. You had two different competing companies. That one made a product called, and I guess they were like multi-purpose for audio-visual things. One of them was called the UltiCart. The other was called the MultiCart. And the one manufacturer sued the other, claiming that there was a advertising injury for trade disparagement because the MultiCart was saying it was the best and did all of this. After they sued the MultiCart people, they tendered to their carrier who declined coverage. And the reason was that there was no mention of the UltiCart, the competitor, in the ads. And they said, well, there's no basis for trade disparagement. So there's no coverage under an advertising injury when there's no mention of it. Because even though they claim trade disparagement, you have to at least mention the other product for there to be a trade disparagement claim that's covered under the policy. The Hartford Casualty versus JR Marketing. In this case, Hartford had originally not accepted the defense of the case in a case involving its insured, and afterwards there was a declaratory relief and bad faith claim that went on. In that case, they were ordered to defend. So Hartford defended. A significant portion of that, though, is the order also did say that although since they hadn't defended, they couldn't raise an issue about the rates, they could raise an argument about reasonableness. So after the case is settled, they then turned around and sued the insured's attorneys and said, you guys have got all kinds of things in here that had nothing to do with this case. You're committing, fraud against us, and we don't have to pay these claims, or we don't have to pay these bills of the attorneys. And the Court of Appeal held that was appropriate, and they said that the carrier didn't have to pay for things that were wasteful or were fraudulent, as alleged against the firm. Obviously, the firm, I'm sure, had a different position as to whether they were committing fraud. But the carrier said, the Court of Appeal said, it's alleged, there is a basis for it. When the attorneys said, well, really, you have a contract with your insureds, not with us, so your claim for unjust enrichment has to go to your insureds, not to us. The Court of Appeal said, okay, who prepared the contracts that this work was done under? Who prepared the order that was provided that said what the carrier was going to have to pay? This law firm. So the Court of Appeals was not happy that the same law firm was trying to say, go after our client, not us. So in other words, they did have a right to bring a direct action against the insured's attorneys for the claims that they were alleging. And again, that may be more fact-based than some others, but it does kind of open the door for possible claims when the carrier has not been defending, which are otherwise barred under Insurance Code 2860. Pending cases that we have right now, Gradius versus Lincoln Insurance Company. This was a case where the district court has, or the Ninth Circuit has asked the California Supreme Court to give them an opinion on what the definition is for whether something arises out of the use of an automobile policy. Here, the facts are kind of tragic. There was a woman who was on a bus. The bus, she was apparently the only one on the bus at this time. The driver pulled over into a secluded area and then raped her. And so there was a lawsuit against the bus company, of course, and they tendered to their carrier, and the carrier said, this didn't arise out of the use of the vehicle. So that's really the question. And generally under California law, the question has been whether it's a substantial factor in the driving. So the district court has said are we looking at just minimal causal connection or substantial factor? And probably we're going to hear the Supreme Court reaffirm the substantial factor issue, but I think you're going to have to say that pulling over, stopping somewhere dark, and then committing the rape is going to have to involve the truck. So there probably will be coverage in this one. But this has been pending since this summer.
Did that happen on the bus or?
In the bus. Yeah, he pulled over in a secluded area, pulled over off the road into a secluded area and apparently raped her in the bus. Yeah. The other case that's pending is Nickerson versus Stonebridge Life. And this is a case involving a hospital disability policy. The plaintiff was a disabled veteran, and he was hospitalized for various injuries and treatments. The insurance company evaluated him with their own IME, and they paid for 19 days of his hospitalization, but didn't pay for another 90 days out of the time that he was in the hospital. He filed suit, and it went to trial. And as you can see, the jury awarded $31,500 for emotional distress in the case because all of his benefits were paid for by the VA. So this was really about what he was supposed to get from the disability benefits and breaches of contract. So they awarded $31,500 in damages, but they awarded $19 million in punitive damages. So that's again up for appeal to the Court of Appeals because the U.S. Supreme Court has previously said anything over 10 times your economic damages is unfair for punitive damages, and it's unconstitutional. In this particular situation, I think that works out to about 534 times the damages. So the trial court had originally, actually the Court of Appeals and the trial court both had said, we're going to limit this to 10 times, but it was still appealed. So this issue is before the California Supreme Court. Ninth Circuit case, this is another using of a vehicle. We got a Good Samaritan who came upon an accident, and he pulled the passenger from the vehicle after they'd been involved in an accident, and this caused further injuries to the person. So the question is whether unloading the vehicle by pulling someone out of it is considered use of a vehicle for purposes of the defendant's automobile policy. So that was a recent decision. The District Court of Appeals said it was, and that should be considered unloading. I would typically consider taking things out of my car unloading, but I guess if you're taking an unconscious or injured person, that could be considered unloading as well. Liability insurance cases, American States Insurance Company versus Travelers Property and Casualty. This was kind of an interesting case. Particularly, we've all seen them now. The food catering trucks are everywhere. This involved a food catering truck. There was really only room for 2 people in this food catering truck up front. 2 seats in the entire thing. Driver's seat, you had a passenger seat, which typically the cook, which was the wife of the driver, his wife would usually sit in that seat there. Well, on this particular day, they had someone else along with them, so the other person was in the passenger seat, and I believe it was the wife was in the back, in the kitchen area where all the food is made. They got involved in an accident, and the wife was injured, and the big part of the problem was the hot fryer, the top came off, and so hot grease went all over the person. There were some really bad burns. They tendered to the insurance company for the people, Royal Catering, the people that owned there was a suit against Royal Catering. That was the people that owned the truck. Royal tendered to its carriers, and the carrier with the commercial liability policy denied coverage, saying, this is a motor vehicle loss. We don't cover motor vehicle losses under your business liability policy. Well, what the Court of Appeals said in this case is you have to really look at the exclusions and look at the definitions, and one of the definitions in here was coverage for mobile equipment, and this catering truck was determined to be mobile equipment rather than a vehicle for purposes of when this accident happened, because they would pick up the vehicle every morning. In the parking lot of Royal, the couple that did the catering would do all their cooking. They would then drive the truck to the various spots that they would provide food to people, but they weren't really driving the vehicle for anything other than that. So it was determined to be mobile equipment, which therefore was covered rather than excluded under the business liability policy. Regional Steel, this is a case that involved the construction of some buildings, and the insured in this case manufactured rebar that's used, with concrete when you're setting forms or putting together buildings, and they made rebar hooks. The rebar would be bent, and placed into the corners of various things, and that was used to strengthen the concrete or the masonry that was used. Well, in this case, the plans that had originally been approved on this building approved both 90-degree hooks and 135-degree hooks, depending on various locations, but said 90 degrees were okay. So a bunch of the 90-degree hooks were manufactured, were installed on the building. After they were installed, but before the project was completed, one of the inspectors came along and said, you know what, 90 degrees aren't good. We're going to require every one of them be 135 degrees. So you've got the project essentially completed at this point, but you've got 90 degrees that haven't really done anything, and they're still in place. Well, a lawsuit was filed for the defects and for replacing the work, and the company that made the rebar hooks tendered to its carrier, and there was the carrier denied coverage and said, there's no property damage here. The insurer said, well, there's allegations of cracks in the floor and other cracks. But the court said, you can't just infer cracks in the floor mean that it's related in any way to these hooks, because there was no evidence that that had anything to do with these hooks. So therefore, these components were not causing any damage to anything else. There was no property damage. There was no coverage. This case differentiated from the line of cases we see for like in the asbestos world, where there was the Armstrong case where you had ceiling tiles that had asbestos in them and had been installed, and there the asbestos product had to be removed out because it was causing contamination of the entire building. So the asbestos contaminates the building and was causing damage. These hooks weren't causing any damage to any other part of the building. Had they been able to show that there was cracking or other damage, they would have had property damage, but they did not here. Dameron Hospital Association versus AAA of Northern California. AAA was one of several carriers in this particular suit. What had happened was, with Haniff and some of the other cases that follow it in terms of what's owed under medical liens, carriers have taken different positions, so have hospitals. And in this particular case, the hospital had an agreement that would allow it to pursue the third party for the difference between what it collected and what it was paid, or difference between what it was paid by various insurance companies and what it collected. And the court said, that's okay, even though Haniff says that when an insurance company takes this amount, that's the entirety of the bill. What this case said here is that if you have in your agreement with those insurers that you reserve the right to pursue third parties, and if that is very clearly and expressly in there, then you can do so. Did I go too far? I think I did. Centex Homes versus St. Paul Fire and Marine. This was a construction defect case, and in this particular case, Centex was sued by a number of homeowners. There's a shock. And Centex then sued all its subcontractors, another shock. And some of the subcontractors defended, some did not. They tendered on additional insured endorsements. Some of those carriers picked up, some did not. Travelers did pick up the defense and was defending Centex, but under a reservation of rights. Well, Centex filed a cross-complaint against those parties that weren't defending, those subs, and 2 causes of action in its cross-complaint. The other causes of action were all against the subcontractors, but 2 causes of action were against Travelers and a couple of other carriers regarding the participation of the defense. And the lawsuit those causes of action that they sought against Travelers were for allocation and for breach of contract for the good faith duty to defend, because Travelers had not appointed Kuma's counsel. And the argument that Centex made was, hey, Travelers came in here and they're defending us, but they've reserved rights. At some point, they're going to seek to recover some of these costs back from us because there are all these other carriers and subs who should be participating in our defense and aren't. We want an allocation now, and we also want an order that they owe us a Kuma's counsel. And the court sustained the demurs without leave to amend in this case on those 2 causes of action, and said the carriers had no liability because these claims weren't ripe. There was nothing yet showing that the panel counsel that had been appointed had any way of controlling how the allocations worked out. There was no information provided as to what the real damages were going to be. So those causes of action were just too early. Underwriters versus Pro Builders Specialty Insurance Company. 2 different carriers insured in this case. Pro Builders, in their policy under the duty to defend said they had a duty to defend unless there was another insurer providing a defense to the insured at that time. The insured gets sued. The insured tenders to both underwriters and pro builders. Underwriters defends. Pro builders doesn't, saying, you've already got a defense, see ya. This kind of provision is generally referred to as an escape clause, and the more modern trend has been to disallow these and go with a more equitable basis of having both parties share, and that's essentially what the court did here. The court recently held that, yes, your provision says that, but it's unfair, it's not appropriate, and it's not a valid way to escape your liability that you otherwise have. Maslow versus Ameriprise Auto and Home Insurance. In this case, Mr. Maslow was involved in an automobile accident. He had an uninsured motorist claim. He provided all of his information to his carrier. He provided medical bills. He provided information about the accident within about a year of the accident, and the carrier didn't do, at least allegedly, did not do any investigation on its own, and it made no offers, but it did agree to arbitrate the case. 3 years after the accident, and about 2 years after it received all the medical bills, all the information from the insured, the case went through arbitration, and the insured recovered $164,000. Well, the insured had a $250,000 limits for the uninsured motorist coverage, and the insured sued the carrier for bad faith, saying, I should have been given something earlier. You didn't make any offers. You've committed bad faith. And the insurer's position was, your arbor award's less than your limit, your maximum. And the court said, because you didn't show that you've done any diligent investigation of the case, and because you didn't make an offer when it was clear there was some liability, you're on the hook. And the insured was denied benefits he should have had under the policy long ago. He went through the time and trouble and expense of the arbitration. So the key to remember from a case like this is, even if you hotly contest a lot of the issues, if there's going to be some coverage, you got to make sure you make that offer, and certainly make sure your file reflects that you've got investigation of the claim going on as to why you haven't made an offer if you haven't. Scottsdale Insurance Company versus National Continental. This was a case involving use of a tractor and trailer combination. Mr. Lynch was the owner of a tractor that was insured by Scottsdale, and he subhauled out for a company called Western Transportation. Western Transportation was insured by National Continental. Mr. Lynch was involved in a fatal accident, and a lawsuit was filed. The case was tendered to both Scottsdale, the insurer of the tractor, and to National Continental, Western Transport's insurer, that did insure for loads such as this. The Scottsdale policy did provide, in its named description of vehicles, it did provide coverage for this tractor. So National Continental said, hey, look, if you look at 11580.9D, which is the insurance code section that 11580.9 deals with trucking cases and gives kind of priorities of when there's coverage of more than one policy, how do you work out who does what? And in D, what it says is the policy that has that vehicle rated, that's the primary policy, the other one's excess. Well, Scottsdale said, but wait a minute, 11580.9H says when you have someone in the business of trucking, that policy is primary and the other ones are excess. And the court said that's a more general provision than 11580.9D. That's the more specific one because you've got a specific rated automobile here or vehicle. So 11580.9D trumps H. And Scottsdale was the primary policy on this one. Mercury Casualty Company versus Chu. Mr. Chu was involved in an automobile accident in this case with a passenger of his that was, at the time, Mr. Chu was going to college and was living in that passenger's house. He shared a room with him, was paying rent, but it was, I think the place belonged to the aunt of the plaintiff, aunt or some other relative. So he lived in that home, but he wasn't a relative. So when the passenger sued Mr. Chu, he tendered the defense to his auto carrier, Mercury, and Mercury's policy it included coverage for all residents who inhabit the same dwelling, or include the definition of an insured to be all residents who live in the same dwelling. So that meant that the passenger was an insured even though he wasn't a resident relative, which most policies say. So Mercury said, we don't have coverage for the non-related passenger who shared a residence with the driver who was the named insured. And the Court of Appeal said, yeah, this provision is clear enough that you don't have coverage in that situation. Elliott versus Geico. In this case, Ms. Elliott's husband was on a motorcycle and was involved in an accident with Ms. Schaefer, and he was killed. She was coming from the bar and restaurant that she worked at and was allegedly drunk at the time of the accident. Ms. Schaefer had a $15,000 automobile policy. She tendered and paid the limits of that policy to Ms. Elliott on the claim. Ms. Elliott had underinsured motorist benefits on her husband's policy of $100,000. She did bring a UIM claim and against Geico, who was the carrier for her husband's policy that had the $100,000 limits. And Geico said, well, wait a minute, not only did you get the $15,000 from Ms. Schaefer, but her employer, the bar owner, their carrier paid you an additional $250,000 under a liability policy. So you received more than $100,000, so you don't get anything under the underinsured motorist policy. And Ms. Elliott said, well, that's not auto. You only get to offset auto. And the court said, no, if you look at the statute for underinsured motorist coverage, it says that you get to take off those monies paid by any negligent tortfeasor, by or on behalf of any negligent tortfeasor. And in this case, it was $15 paid by Ms. Elliott and another $250 paid by her employer on her behalf and on its own behalf under the liability policy. So therefore, since $250 and $15 add up to way more than $100, she had nothing that she could get under underinsured motorist benefits. Transport Insurance versus Superior Court, R.R. Street Company. This was a case involving PEs, the chemicals that are used in dry cleaning, and so there are contamination cases. Vulcan Materials was a sub to Transport, or not to Transport, but to R.R. Street and Company, pursuant to a contract for some of the work that was being done. And when the contamination suit arose, Street tendered to Vulcan and to Transport, who'd written a policy for Vulcan. Previously, there'd been a ruling that Transport had to defend Vulcan in the case, or in cases of this nature. So R.R. Street said, you have to defend me as well. I'm an additional insured under the policy. It's already been determined that you owe coverage here. But what the court said, the Court of Appeals said in this case is, when you're interpreting the term underlying insurance, because this was an excess policy, and they had to determine what underlying insurance was available or had to be exhausted before the excess policy would come in. In this particular case, you've got to look at the reasonable expectations of the named insured, not the named insured, but the additional insured, since they were the one who were tendering. So that made a difference because the insurance available to R.R. Street was different from that available to Transport. So you had to look at what was available to R.R. Street as underlying insurance before determining when the excess applied. Davler versus Arch Insurance Company. This is just a horrible fact situation. It was in a company where the employer went into the ladies' restroom and saw that it was a mess and thought that somebody had intentionally made a mess or might have just been having problems. And she thought, well, I'm going to strip search every female employee to see which one of these people might be using feminine hygiene products at this point in time, because they'd stuffed up the toilet and that was one of the things going on. So they took every employee, made them be searched by another female employer. I'm joking, of course. It's a horrible, horrible thing. And of course, naturally, these people sued. They sued for the humiliation, false imprisonment, everything else against the employer. The employer was insured by Arch Insurance and said, you got to defend me against these claims because I do have coverage for personal and advertising injury, which would include false imprisonment, which is one of the claims here amongst all the others. So I should be covered for this. And the court looked at that and said, your employment-related practices exclusion in the policy says you're not going to get coverage for employment-related practices such as harassment. They used other phrases, humiliation, embarrassment, things like that. They didn't use the words false imprisonment, which would be a personal and advertising injury claim. But the court said, look, everything that they're alleging here is employee-related practices that involve harassment, that involve intimidation, that involve humiliation. This is not a covered claim, which is, I think, the right decision. Gonzalez versus Fire Insurance Exchange. This is a case. I actually lived for years down near De Anza Junior College in Cupertino. That's where I went before finishing off school. And about 8 or 9 years ago, there was an unfortunate incident where allegedly most of the De Anza baseball team was involved in sexual assault on a young woman. Went through the criminal courts, nothing happened. Went through they called in the state attorney general, nothing really happened with these guys. A lawsuit was filed by the victim against several of the alleged participants, including Mr. Ribigliotti, who was one of the young men involved. And it wasn't necessarily alleged that he was involved in actually sexually assaulting her, but it said he and the others were involved, and at the very least closed the doors, put things on social media, and did various other things. He tendered to his parents' insurance carrier the claim. There were 15 causes of action against him, including false imprisonment, negligence, slander. Again, these things that were put online. But the court said that regardless of the title of any of these causes of action, when you look at the acts that were complained of in this complaint, every single one of these was intentional. And there was no basis for determining that there was an accident as determined under the policy. So there was no coverage under the policy. Upasani versus State Farm General Insurance. This is a case that involved a bad divorce and a bad breakup. The father had the child. The mother worked with others to try and take the child, or allegedly did, and was caught. And the insureds in this instance were, I believe, it was a detective agency or persons of that nature. They were sued for allegedly conspiring with the mother to abduct the child. There was no basis for coverage under this because, again, you can't negligently conspire with somebody. And the only alleged claims against these folks were for conspiring to commit an abduction or steal. So you can't just kind of back into that. Either you conspire or you don't. Crown Capital Securities versus Endurance American Specialty. This was a securities matter. When Crown Capital changed carriers to Endurance, they filled out the application. They did report this one loss run. Their loss run report did include this one pending claim, and they put down facts about that, but they didn't say anything about whether there might be anything more coming out of it. There were, in fact, another 100 people that were kind of lining up to do the exact same lawsuit because they were allegedly built the same way. The carrier denied coverage on all these other claims, saying that it all arises out of the same events and that these events had been disclosed on the application and therefore aren't covered. They are not covered claims, and the Court of Appeals said that's correct. Bach versus Hansen. This is a case that I found kind of chilling. In this case, the claims adjuster was found to be potentially liable individually for fraudulent misrepresentation of claims benefits. There was a storm, and the Hansens, the Bachs, called out their insurance company and said, we've had damage. A tree came down into our living room. And the allegations in the lawsuit that are listed and in the summary of the case, it's a bad set of facts. But what they allege is that Mr. Hansen came out, he was their insurance adjuster, he came out and they said that he moved some of the items before taking pictures to make it look like there was less there. They were asking about whether they could get paid for cleanup, and he said, well, there's a dustpan, go clean up. They say. Again, the plaintiffs alleged all of this. So they alleged some pretty heinous facts as to what he did. But the bottom line, for purposes of this lawsuit, is they said that he didn't disclose all the coverages. They asked about, costs of cleanup. They asked about what types of coverage they would have. He made low offers to them, and so therefore they said he fraudulently misrepresented what was going to be covered and what was not. And along with the bad faith claims that they had against their carrier, they sued him for fraudulent misrepresentation of claims. And the defense to that was, well, wait a minute, he's an employee of the insurance company. Your contract is with the insurance company. You don't have claims against him. You have a claim against the insurance company with whom you have privity. And the court said, well, you may have contractual rights, but you also have tort rights, and if someone is misrepresenting their claims fraudulently, that's the basis for an individual and separate claim, and always has been. And to an extent, that's true, but this case, to me, seemed a little bit scary. It means all you have to do is allege that somebody's a lot worse than you really are, and you can at least make a claim like this. Graciano versus Mercury General Insurance. This was a case that involved two different automobile policies, two different vehicles, and two gentlemen with the very similar sounding names who lived in the same household. So it was an accident in claims handling about to happen. One of the two men was involved in an accident with the plaintiff. The plaintiff's attorney had information on the name, had an insurance policy number, provided that to Mercury. Mercury then took a look and determined, okay, we had this policy number on the person with this name, but that policy is lapsed. It's no longer valid. So they didn't really worry about it. Meanwhile, things churn on. The attorney is still contacting people, and I think actually they dealt with Mercury's. Do they have an office in Roseville? I think they dealt with them up in Roseville, and the other one was in Pleasanton. But they had the two different offices they were dealing with. They found a second claim number, which was the right claim number for the right vehicle, or for the wrong vehicle, I think. But anyway, in any event, they made another settlement demand for the policy limits under this. And the carrier in the office where they originally looked at it and said, we don't cover under this policy, under this name, they didn't accept it. But then ultimately when they determined, oh, okay, this is who they're talking about and we do insure this person, they contacted them and said, we'd like to accept that policy limits demand now. And the plaintiff's attorney said, nope, not going to accept it. You had your time. So the plaintiff, they thereafter instituted the bad faith claim. The limits were paid. And they went on with the bad faith claim and had sued the carrier for this and said, you're responsible for this. You're going to owe us extra contractual damages. And the court said, not in this situation, because the carrier had done everything it reasonably could. And you, the attorney for the insured, for the claimant in this case, you provided them with the wrong name and policy number in the first place. It's not their responsibility to track it down. Once they found it, it was, but they aren't required to be mind readers. McMillan versus American Safety. This was a case where the general was named as additional insured under multiple subcontractor policies, and they settled with various carriers and received more than their total defense costs. I think they had like $640,000 was what they had paid. I'm sorry, I started at 2, right? 10 more minutes? 5 more? Okay. All right, I'll wrap up pretty quick. Anyways, this case, they recovered more than they had expended in terms of defense costs and the indemnity dollars that they had paid, but they didn't recover all of it until they had to sue these other folks for bad faith who hadn't defended. So the defendants that went forward in the case said, well, wait a minute, they've got all their damages made up, and the court recognized there had been no allocation as to how much was paid by some of these folks for monies that they owed on the defense or monies that they would have owed for being sued for failing to properly defend in the first place. So what that meant was, even though on paper McMillan had received more than its total payout, it was entitled to at least make the claim for bad faith against the remaining parties. We'll skip Albert. Yeah, in this particular case, 21st Century, in this particular one, 21st Century had been defending the case all along, but there were other potential policies. There was one policy written for the actual driver, then there were potential policies that might have covered the driver because he lived with his aunt and his grandmother. So the plaintiff had argued the aunt's policy and the grandmother's policy also apply. We're making demands for all those policies. And the carrier said, no, we'll offer you the policy limits of his policy. They turned that down. The case went forward. The plaintiff entered into a settlement with the defendant. They stipulated to a settlement and then assigned the rights of the defendant against his carriers. to go on and proceed for any bad faith claims. So the plaintiff in the underlying case then goes ahead and takes those assigned rights and sues the carrier saying, you owe us defense for all these claims. And the court said, no, not a judgment, but a stipulated settlement between the plaintiff and the insured is not binding on the carrier here because they've already been defending. They were defending the insured the whole time along. And a stipulated settlement where the carrier is not defending, that can be done. But where the carrier is defending, you can't bind the carrier with that. Let's see. I'm going to skip to Lee versus California Capital. We'll finish with Grabo, but Lee versus California Capital insurance case, there was a fire claim, and there was a dispute between the owner of the building and, because it was a commercial, it was a rental, and there was a dispute between Lee and the carrier as to how much damage there actually was. So they went through the appraisal process. They were ordered to participate in it, and Lee produced an appraisal that was for some $800,000. The carrier had an appraisal of around $100,000. Lee's appraisal included other floors, included other damage, included rebuilding some of these floors with windows that didn't exist originally. And the carrier had argued, well, wait a minute, you can't have an appraisal that lists items that don't exist, such as these windows and such as some of these other matters. They went through the appraisal process. The appraisers basically threw up their hands and said, here's one number, here's the other number. So they went back to the court to decide what to do. The court originally said, well, that's how it's been decided, and we're just going to roll with that. They went up on appeal, and what the Court of Appeal said is there has to be at least some basis for the appraisal figure being claimed by the plaintiff. So you can have disputes. That's what the appraisal process is about. But where something doesn't even exist, you can't include it. The last case, Grabo. This was a case that was just decided last month or so. And the Grebos had a home that had kind of a deck on their second level, and they had some living area down below it. And there was some sagging going on, so they called in a contractor who took a look at the place and said, you've got real problems here. These metal posts that are holding things up, they're rusting away. This whole thing is going to come down pretty soon. I would encourage you to stay out of the area above this deck, and I would also say you should talk to a structural expert. The structural expert that they hired came out and said essentially the same thing. So they then went out and started doing the work. They ended up ultimately spending $90,000 on making these repairs. While they were in the process, they let their carrier know, we have this claim and we want to have our property repaired. And the carrier said, well, no, your coverage is for property damage, but it doesn't include imminent collapse. It specifically says you have to actually have collapsed. You can't have something deteriorating. So in this case, since the building had not fallen down yet, they couldn't seek the damages for making repairs. They would unfortunately have to wait and then make that claim for it to be covered. The second argument that they made was, well, wait a minute, if there is a coverage under the policy, we have a duty to mitigate our damages. So therefore, it was incumbent on us to get this work done right now, and you then have a duty to reimburse us. And the court said, that's all true, but again, you're putting the cart before the horse because we don't have coverage here yet. There's no coverage for an imminent collapse, so therefore, again, it's all in the insured's pocket at that. I think we are out of time on this, and I'm sorry to rush through some of these. If there's any of these matters that you have any questions about, feel free to come up to me on one of the breaks, or as I always tell people, send me an email. I'm more than happy to answer your question. And what I also tell people is if I can't answer something, I'm more than happy to look it up, because I figured if someone needs to know it, I might as well know it too. So I'm always happy to answer something. I'm also not too proud to tell you if I don't know an answer off the top of my head. So please do that. And as far as movie stumps go, I would defer to Tom in a lot of instances, but 80s stuff, 70s stuff, I got you. Thank you, folks.